Good afternoon and welcome to our webinar, which is going to go through options for artists and entertainers. Thanks for joining us. Apologies for any delay. We had a couple of technical issues getting everything set up, but we'll get you straight along and we'll start going through everything and we'll go from there. Because we're going to be going through basically the visa options for artists and entertainers, there may be, we're going to try and go through and cover pretty much everything in terms of the O1, the P1, and the green card side of things. But if anyone actually has any questions, you can actually type them in, I think, on your end, and we should be able to go through any questions you may have later on at the end of the presentation. So, without further, I think let's get moving on everything. So just to give you a quick overview, the O visas, there's a couple of different types. So the O1 visa is supposed to be for those with, the idea is aliens of extraordinary ability. Now an alien of extraordinary ability is, the standard is very different depending on what field, the position that you're going to be working in the US is classified under. So there is an O1A, which is for science, education, business, or athletics, and also for fashion models. There's also the O1B, which is more for those in the arts or the motion picture and TV industry. Now, arts is generally classified as artists, musicians, VFX artists, graphic design, dancer stylists, art directors. Pretty much everything in the art field comes under the art standard. The motion picture and TV standard is for people who are going to be working in the motion picture and TV. The idea behind this is that the O1B is technically a slightly lower standard than the O1A. The reason being is because US immigration, they actually want to encourage those in the arts, those in the motion picture TV industry in the United States, and therefore they allow this kind of people to hit this slightly lower standard than the O1A, which is pretty much for, like I said, science education is pretty much for everyone else. If you don't fall under arts or motion picture TV, we're going to have to try and classify it and meet the standard of the O1A. And we'll go into more detail about the specifics of all of these. This is really just an overview right now of the different visa types. Now the O2 visa, this is actually a really useful visa. The problem with the O2 visa is it does require that there's an O1, so you need to be attached to someone who is already on an O1. Now the idea is that an O2 person is someone who is essential support personnel. So generally speaking, if you've got an O1 actor, for example, they can technically bring out someone as an O2, and that person can work on an O2 who is essential to what they do. So this can be often manager, agent, that kind of thing. The O3 visa is basically available for dependents. This is for spouse, children of the O1 principal or the O2 principal. There is no work authorization allowed on the O3, but they can be here and they can study. So moving swiftly along, the O1B visa standards. Now, I mentioned that it's a lower standard. This is actually kind of explaining exactly what that lower standard is. And it's kind of can be a little bit of a tough one. But they technically do have different criteria that wouldn't otherwise be kind of listed. And the way this works is as follows. The O1B for arts, the O1 in this context means distinction, which is generally speaking is demonstrated by a high level of achievement in the field of arts, as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. Now the difference here is you're not necessarily looking for someone who's really at the top of their field, although that can help. This is a lot more kind of looking at someone who actually has this kind of distinction. They're substantially above the others, the ordinarily encountered in the field. And this is where we really want to kind of get into this distinction and kind of show that this person is higher than others in that field, and it's a, like I said, it's a lower standard than the O1A, which would be the relevant standard for people in the science and the education and the other industries. So O1B, film and television, this is where, again, as we mentioned before, this would be where someone's actually going to be working in the film and TV industry. The alien must be recognized as having a record of extraordinary achievement. And this standard is demonstrated by a very high level of accomplishment in the motion picture and television industry, as evidenced by a degree of skill recognition that's significantly above that is ordinarily encountered. Again, the idea would be kind of outstanding, notable, leading role, this kind of thing. As I mentioned before, these are both slightly lower standards. Which one of these standards is higher than the other one is kind of tough to say. Some people say that the O1B film TV is technically a lower standard than the O1B arts, but to some extent it's all just, you know, a different kind of terminology, different criteria, that kind of thing. But it's good to know which one applies to you. So, going into the O1B in more detail, the O1B, so first off, if you have a major award, such as an Emmy, Grammy, Oscar, BAFTA, any one of those awards, at that point, you're pretty much fine. You only need to show, we basically file your petition with a copy of the Oscar or picture of you holding the Oscar, and because you've got that one-time achievement, you're good. They should just approve you. They wouldn't need to look at any of the other criteria. Now, the question I often get asked is, well, I don't have an Oscar. I'm not going to get an Oscar anytime soon. Do I still qualify for an O1B? And the answer is yes. You basically just have to show 3 of the following criteria. And this is one of those things where most of the time we're going to try and, if we're helping with the petition, we're going to try and get as many of these criteria as possible. We're going to try and hit maybe 6 or 7 if possible, so that if the immigration officer doesn't agree with our interpretation on a couple of them, at least you're still going to, you know, end up with at least 3 criteria being hit. So we're going to go through the criteria now. You can kind of have a think to see which ones you might qualify under. The first one being the foreign national has performed and will perform services as a lead or starring participant in productions or events which have a distinguished reputation. Now, this is where credits come into play. And this is why a lot of times with actors and other people in the motion picture TV industry, it's always good to make sure that IMDb is updated with all of the information about your credits and the starring roles you've had. Because I know sometimes we look at IMDb and people are like, oh, well, it's not showing up there yet. The problem can be, in certain situations, immigration officers, you know, we can prepare the cases as well as we can. Certain immigration officers, it seems like, will just look at the IMDb page for you and really be looking to see if you meet, you know, if you meet their kind of, they may have this kind of their own standard as to what an O1 actor should look like. And they might be saying, okay, well, I want to look at the IMDb page for this person, and they need to have this number of credits. So in order to make sure that if they're looking at your credits, they see everything that you've got, you really do want to make sure that the credits are updated on IMDb. In terms of showing that you are a lead or starring participant in productions or events, the idea that there's 2 parts to this. There's the lead or starring side of things, which basically means, you know, we have to be able to show that you were a star. You weren't kind of just a walk-on part in a TV show or something like that. We need to be able to prove that you're a lead or starring participant. Now, this can be tough. You know, if you've got a named role, oftentimes this is something we can point to. If you're one of the first people listed on the IMDb page for that particular production, then we've probably got a good shot. Obviously, if you're the director, for example, of a show, then it's relatively almost pretty much assumed that that's a lead or starring participant. You're critical to that particular production. The next part of this is to show that this production or event has a distinguished reputation. Now, this is often one of the issues that we see, because we have a lot of people that, will have directed a short film, or starred in several short films or several movies that really didn't get much circulation. The problem at that point is being able to show that that production or event has a distinguished reputation. And this can be proved by showing that let's just say a film. Let's say if you've starred in a film or you've directed a film, if we want to show that that film or the commercial has a distinguished reputation, we want to show that it's maybe won awards, it's been exhibited at showcases or festivals, this kind of thing. And that would be kind of where our focus would be on that side of things. So yeah, for the first criteria, we want to show lead or starring participant, which would be a lead credit, in productions or events which have a distinguished reputation. The second criteria is basically press. The idea is you've shown that you've achieved national or international recognition for achievements as shown by critical reviews or other published materials by or about the beneficiary. Now the press side of things is often very important in these cases, and this has to be press that, preferably is about you. It's not just necessarily about, if you were in a movie or something like that, it's not just press about the movie that somehow mentions you somewhere. Obviously that's going to be good, but the idea is really that it actually explicitly mentions you and your role in it and your work in that particular field. Press is one of these kind of weird ones because, you can have a lot of press in smaller local publications and it won't be as useful as, maybe 2 or 3 pieces of really good press, an interview or something in a major newspaper or something along those lines. The idea really in this context is to get press from as big as possible, in terms of the newspaper or the readership or the circulation, just being able to show that you were featured in this particular press that was widely circulated and read by a lot of people. And this is where kind of internet press also comes in. If it's online press, that does also work. We don't just need to look at magazines, newspapers, print media. We can look at online press. This can, to some extent, include things such as industry blogs or these kind of things, but we are going to want to really be able to point to hits or something to show that this particular website or this particular online press gets a lot of attention and a lot of readers, and that can be tough to show in certain situations. Now, the other thing on the press side of things is that it doesn't necessarily have to be press from the US. It can be press from your home country or other countries abroad. One of the things we see a lot of times is, press about you and how you've, gone to the US and made it and become a big Hollywood star, this kind of thing. If we can get press or an interview in a decent-sized newspaper from back home, from abroad, that can also work. But yeah, it's kind of one of those things. The more press, the better, but we also want to focus on the quality of the press. Is it good press, or is it, is your name just listed in there among several others? This is also where reviews can work. If you've been in, and I'm kind of going back to the acting side of things, but I mean, if you've been in a play or something like that, and you've had good reviews, or even negative reviews, this can kind of count as national or international recognition. The third criteria, and this is another one that, the third one we actually often will kind of pair with the first one. The idea here is that you've performed and will perform in a lead, starring, or critical role for organizations and establishments that have a distinguished reputation. This side of things often works in the context. So, with the first criteria, we were talking about actual credits. You actually having been a part of films or TV series or something like that. Now we can often point to number 3 and look at the production company, for example, behind the film or the TV or whatever other production it is. And if, for example, it's been a major feature film for a major production company, we can show that by being a lead or starring participant in this major film, you're also performing in the lead or starring critical role for the organization behind the actual the film, because in that regard it's the production company itself. The production is obviously very critical to the production company, because without the production, the success of the production, where would the production company be? So that would be the idea often here. This can also be done in numerous other kind of ways. For example, if you've performed in a commercial for a particular major company, then we can point to the company and say, this, because of your role in this commercial, we can show that you've had a lead or starring or critical role for the organization, which may be, a major car company or something like that. This, again, in terms of showing evidence, we're looking for credits for that company. And we can also show a lot of these criteria, especially 1 and 3. We can definitely show that you've performed in this lead, starring, or critical role for the organization and or production by reference letters. Getting people who are involved, a high level, for example, president of a production company or director of the feature film, to sign a letter, write a letter saying that you were critical to that particular production or event. The 4th criteria that we're going to look at today is the record of major commercial critically acclaimed success. Now this is one of those ones that doesn't necessarily work in all of the arts field, but if you've got reviews about you that can potentially, obviously positive reviews, then we can talk about the critically acclaimed successes. If you've been part of a major movie that did really well at the box office, if we're able to somehow equate you to that success, we can then show that you have this record of major commercial success. So, for example, if you've been in several movies, they've all done really well at the box office, then this often means we can show that, you're the one who has the record of major commercial success, because a lot of the movies you've been in have done really well. So that would be the idea there. But remember, the O1B also works for arts. So in this regard, this can also apply to musicians. If you've released something that's done really well on the Billboard charts, or something, you've had really good album sales, these are all things that we can kind of point to. Now, this is sometimes hard to show. I mean, we can often, if it's motion picture, box office receipts are generally pretty easy to evidence and show through news outlets, IMDb, this kind of thing. But in certain situations, if it's a commercial, for example, it might be hard to show that this commercial was a commercial success, or a critically acclaimed success. Often at times in this regard, we would have a reference letter from potentially the company whose commercial you were a part of, perhaps evidencing that, from their records, this particular commercial helped drive sales in this particular demographic or something like that. Because a lot of these companies do have that information, and if we're able to get it and show that that relates to you and you therefore have a record of major commercial success, we're good to go from that. Now the 5th criteria is this: receive significant recognition for achievements from organizations, critics, government agencies, or other recognized experts. And this is what I've kind of touched on already in terms of the expert reference letters. The idea here is that you can get other people who are considered experts in the industry to sign reference letters confirming that, they believe you to be the best thing since sliced bread. You're just at the top of your field, never witnessed anyone who's, as good or meets the same kind of standard. And this is one of the key points because it's its own separate criteria. And oftentimes in this regard, we will get other people that generally we tend to shoot for around 6 to 8. So we would ask you for maybe 6 to 8 names of people who are big names in the industry potentially, or at least people that could be considered experts. And the way this kind of works is really we want people that we care what they have to say. We want people where, the immigration officer reading the letter from this person, it makes sense that that person is even submitting a letter. If it's an actor who's really done nothing, then it's probably going to be less useful. If it's a director who's directed 100 movies and they've all done really well and he's won an Oscar, then at that point it makes sense that we're asking for his opinion because he's been in the field for maybe 20, 30 years. He's got all of this thing. He knows what it takes to be at the top of the industry. And that's the idea, is that these letters are very objective, and they're basically letters that are talking about you and your contribution to the field and your abilities and this kind of thing. And these reference letters not only can meet this particular criteria, they can also help us build the case on the other criteria. We can have them talking about how you were critical to a particular production or a particular organization and really focus on that side of things. The last criteria on here is that you have or will command a high salary or other substantial remuneration in relation to others in the field. This is very tough to hit this one. Immigration is often very tough on this particular criteria just because they really want to see that you have a very high salary above, kind of even the top people in your particular field. They want to make sure that you're earning quite a lot more than them. This is possible. If you have earned a lot, we can show contracts, we can use pay stubs, tax returns, that side of things. If you earned a lot more than anyone else in your field, in your particular location, in your particular country, that can work as well. The idea is just to show that you have earned this substantially over what others people in your particular field doing the same kind of work are earning. This is often one of those things that we see, if you're an editor or in some other kind of arts field and you're paid a substantial amount for one project that maybe only lasted a day or two, this is often where we see this come into effect, because then it's very easy to show a contract or some kind of invoice showing that you charged X amount for only one day of work, and that puts you way above most others in the field. A couple of points to be aware of is you need to be clear on what you will be doing and what the field is. The idea here is that the O1 is job specific, so once it's been approved, the idea is that you can only work in that particular job. So if we often see this in the context of, director, producer, someone who's got credits as a director, producer, actor. The O1 has to be filed in whatever it is that you're going to be doing, and we have to show extraordinary ability in that particular field, because once it's approved, you can only work in that particular as a producer, as a director. The proper documentation of each criteria is definitely a key to this. We need to be able to evidence everything. With each of these criteria, it's fine for you to say that, yes, you were a critical leading role in this particular production, but if we can't evidence it, if we don't have a letter from someone at the organization, or if we don't have you listed on IMDb, it's going to be really hard for us to actually prove that you meet that. The last thing, as I mentioned before, is that we do try and meet as many of these criteria as possible. If we can take a really good shot at maybe hitting 5 of them, chances are, even if immigration isn't convinced on a couple of them, they're still going to approve your case because they're going to say, yes, okay, you've met the minimum 3 required, and therefore approve your case. So, as I mentioned before, classifying the foreign national, which occupation, this is where we're really going to look at which field you have and will perform in. The field is often very important because, as I said, we really want to show that you're kind of, to some extent, at the top of your particular field. And this is kind of where we really want to make sure that that field is potentially very narrowly tailored. If we're trying to show you're the top, for example, in the art world, if we're just trying to say you're the top artist in the world, that can be a little bit tougher than showing that you're the best watercolor artist or something along those kind of lines. So by limiting the field somewhat, it tends to be a little bit more straightforward in terms of showing that you are that high up in that particular field. Also, in terms of the position, the idea of actually having these multiple positions often leads to us saying, okay, well, what are your credits what are you strongest in? And this is kind of where, in certain situations, if someone has been a director, a producer, a writer, we're going to look at their credits and see, okay, what are you strongest? Which one of these positions do you meet the most criteria for the O1? If you've got a lot of credits as a director, but very little as a producer, it might be that the O1 is going to be stronger as a director. Obviously, this doesn't necessarily mean much if your position here is supposed to be a producer, because at that point, we really want to make sure that we're filing as a producer, because otherwise you're only going to be able to be a director when you're approved. New media is definitely a good kind of area for these O1s, especially in the arts. We have had approved O1 visas for bloggers, gamers, people in reality TV. These have all worked, but again, it's a case of really classifying you and classifying your position. So the next stage is really, like I mentioned, O1 Arts or O1 Motion Picture, choosing which standard we're gonna kind of go with. Again, this comes down to what you're going to be doing in the US. If you're going to be working in the motion picture TV industry, we're going to have to get advisory opinion letters. Otherwise, immigration will RFE you, which basically means that they issue a request for evidence, asking that you present a letter from a labor union or management organization. Now, the way this kind of works is, for example, let's say an actor. Once the entire petition is ready for an actor, we've got everything ready, we're about to file to immigration, what we have to do is we have to send it off to the unions, and this is SAG-AFTRA and the NPTP. We send both a copy of the entire petition over to them. They review, they make sure everything's good. If they agree, they send out a no objection letter, and we go from there. If you're not going to be working in the motion picture TV industry, then it's going to be a case of actually just kind of sticking with the art standard, and this needs to be argued in the support letter. Petitioner requirement. For the petitioner, in general, like I said, it's employer specific. So if you have a U.S. employer, a U.S. agent, or a foreign employer through a U.S. agent, this has to be who you're going to be working for. If you have a production company file for you, that needs to be the person you're working for. Without having another O1 approved for someone else, you can only work for that particular U.S. employer. You cannot self-petition on an O1. You have to, the idea is that the O1 isn't for self-employment in the US. The O1 is to allow you to work for an employer, so you do need to have that employer. Like I just mentioned, you can have concurrent O1s, so this would be a case of having multiple O1s if you have multiple employers. So if there's several production companies, they all want to hire you for different TV shows or movies or something like that, then you can work for multiple production companies, but you need to have concurrent O1s for each one. To explain further, the employer can be, basically the petitioner can either be an employer. This would be, for example, where you've got a situation of full-time employment. For example, if a production company is sponsoring you on the O1, the idea is that you're going to basically work for anything that comes up with that production company. This is often the context with, for example, renowned chef at a restaurant. The restaurant's going to sponsor that O1 chef. That chef is going to be full-time employed with that restaurant, and without other authorization, that O1 can only work for that restaurant. The same thing applies with VFX artists. If a studio has sponsored them, you can only work with that particular studio. This is very much the kind of standard full-time employment side of things. The idea is that it makes it a little bit more straightforward because we only need a contract. We don't need an itinerary for you, because the idea is, really during your period with this employer, you're going to be employed full-time. So if this production company, if this restaurant, or if this studio has any projects, you're going to be working on them. This makes it a little bit more straightforward in terms of asking for a full three-year visa because of that. Agent as petitioner. The petitioner can also be an agent. This can work in several different situations. The agent can be an employer, agent on behalf of multiple employers, or agent on behalf of a foreign employer. The idea in this situation is that you need a contract or deal memo detailing the specific terms of representation and compensation, along with projects and itinerary of events to show that what you're going to be doing. The idea is here you get some flexibility, because if your petitioner is an agent or a manager, you can have additional projects later on without having to file an amended petition with new production companies, that kind of thing. But the problem with this is immigration will generally only approve your visa for the length of time that you've actually got projects lined up for. If you don't have projects lined up for the full 3 years, they could restrict you based on that. So if the petitioner is an agent, you may need to show additional deal memos to show that this is all fine. So the O1 event. An O1, like I mentioned, may be approved for up to 3 years at a time. Petitions are only approved for the duration of the event as detailed in the petition, itinerary, or contracts. The deal memos, if, say, you're going to be petitioned by an agent, you have a production company with a deal memo saying, look, we want you to work on this particular feature film for X number of months. You're going to be required for pre-production, for post-production, for potentially for publicity, this kind of thing, and therefore we require availability in the US for this amount of time. The idea is you really want to try and show as much as possible that you've got these legitimate projects lined up for as long as possible. Because if you're only able to show deal memos for a 1-year period, there's a good chance immigration, when they approve you, may only approve your visa for 1 year. The deal memo, generally speaking, needs to make sure it lists dates, project names, remuneration, job title, location. You also want to try and include an itinerary whenever possible, and go from there. If there are gaps, if you have like one deal memo for this year, one deal memo for later next year, and there's a gap in between, tends to be fine as long as you can string together the various events. As we discussed the consultation requirement earlier, if you're filing in the arts, this really should be a national organization, an application in the US. An organization in the US. For example, AFM if you're a musician, singer, composer, VES if you're a VFX artist. In the field of TV film, it's generally a management and an advisory opinion, such as MPTP, SAG, AFTRA, DGA, PGA. These consultations do normally cost. You're normally talking between around $250 to $500 for each consultation. If no appropriate union exists for your particular position, you can normally use a peer consultation letter. Generally speaking, you can check the union website for guidelines on exactly what documentation they want in order to issue a peer consultation letter, and go from there. What do you do in an event of an adverse opinion? So if AMPTP comes back to you and says, nope, we don't think you qualify, we are objecting to this petition, the opinion is not binding on immigration. You can still submit the petition, but it could be a warning sign. It could mean that, if the union is disagreeing, it could mean that the case isn't necessarily as strong as you think. Or it could be just that they are having issues with things that may not necessarily be applicable. Basic filing procedures. So you get your petitioner, who can be either an employer or an agent manager. The idea here would be then you are going to look to show you meet at least 3 of these criteria. You make sure you've got a deal memo or contracts to show you've got upcoming projects coming up. This can't be speculative employment. If you've got a contract that says we may need you if this goes ahead, it's probably not going to work for immigration purposes. Consultation letter, yes, you're going to need to be able to show consultation letters and advisory opinions. If your petitioner is an agent manager, you must have a contract with terms, and sometimes you're going to also need an itinerary of events. In a situation where the agent is the petitioner and there's multiple employers, multiple production companies, the agent really only needs to sign a contract with you. The employer themselves, the different production companies, would be then giving you deal memos that would show that they have projects lined up with you and they require you to do this particular thing. So you can have one kind of representation agreement or contract with the agent or manager, and all the employers basically issuing you with production deal memos between basically them and you. The idea is with an agent manager, you do have that extra flexibility to kind of take on projects on your own almost, as long as that agent-manager relationship still exists. The documents you need for filing, the forms are basically I-129, I-129 OP supplement. You'll need to submit a support letter, the evidence obviously that you meet these criteria, consultation peer letters, deal memo, employment agreement contract, which has to be signed by the petitioner, and an itinerary of events. The petition is basically either filed with CSC, which is the California Service Center, or VSC, which is the Vermont Service Center. Some people always ask, is one better than the other? It's really tough to say. The idea is that if you're going to be employed on the West Coast, you need to file to California. If you're going to be employed on the East Coast, it's generally VSC. I would say sometimes people see that VSC is a little bit better on certain cases because CSC being, the place that covers Hollywood, they see a lot of actors, producers, this kind of thing, filing O1 petitions. So sometimes people worry that CSC is going to, almost the officers there will kind of compare you to everyone else that they see. Maybe on the East Coast they don't see quite as many, and therefore VSC might be a little bit more impressed by your credentials. But it's one of these things. We generally see approvals come out of both, and a lot of this can just kind of depend on which officer you get. Normal versus premium processing. So if you file with regular processing, you pay $3.25, which is the regular government filing fee. Generally speaking, we're seeing right now adjudication in about 4 to 6 weeks. Premium processing, you pay an additional $1,225 government filing fee, and they adjudicate your case or request additional evidence in 15 calendar days. What that means is within 15 calendar days, you either get a decision, either an approval, or generally speaking, you'll get a request for additional evidence. When you get the request for additional evidence, they do normally give you 3 months to respond. So you have time to, they'll come back to you and they'll say, okay, we think you meet 2 of these criteria. we're not so sure about the others, we don't see enough evidence, can you respond and give us additional evidence of this other criteria? And that would be your chance to kind of almost have a second shot at it and respond with as much detail as possible. Once you've responded and they receive your response, they normally take 15 calendar days to make the final decision from there. Jurisdiction-wise, like I mentioned, this is based on location of employment. If you're working in multiple locations, the idea is that it's supposed to be based on location of petitioner. So if you're going to be working all over the US, your agent is in New York, then we're going to be filing to VSC. A couple of tips for you on the O1. Save everything. Anything that has your name on it, you should save as evidence. If you ever get press, if you ever see newspapers that mention you or you're interviewed or anything else like that, it's a good idea to collect it and keep it. We often see people that come in, they've obviously been very busy with their careers, trying to actually get themselves into this position where they're at the top of their field and they're doing really well in their work, but they often turn down multiple opportunities to gain press, to be interviewed, this kind of thing. So I would say it's always a good idea whenever you get the opportunity to do that, it's good to go forward and do it. In terms of filing an extension, generally speaking, they will only give you a 1-year extension when you file to extend your status. So, the initial O1, you might get 3 years. If you're filing an extension, they may only give you 1 year. If you're continuing to complete the same activities or events specified in the original petition with the same employer. You can sometimes get a 3-year extension if there are new activities, new events, maybe a new employer, any changes in the job. You can ask for an extension of 3 years. They sometimes only give you the 1 year anyway, but we've had quite a lot of success being able to argue that it's a new employment agreement or there's new projects and therefore they need to give you a full 3 years. When you're filing the extension, always make sure you include any updated evidence since your last petition. You want to show that you've maintained your status and you've continued to work in this field. So this would be for example, if you've had an O1 for 3 years, you're going to be sending a lot of the same documentation you sent for the first one, but you also want to include any evidence over the last 3 years that you're still at the top of your field, you're still working, you're still doing your thing. In the arts, if you're filing within the 2 years of your last advisory, and it's the same position, same employer, generally speaking, you can use your old advisory and give the that as the authority. They may request that you send in a new one that's specific to your new project, but technically you're able to use it. So this would be if you got some kind of AMPTP or something like that. Motion picture TV, they usually do ask for new advisories, so keep this in mind in terms of extra fees, costs of extension, and also timing, because you may need to request the advisories. Sometimes they take a couple of weeks to come through, so you may want to make sure you factor that into your timing with regards to filing the extension. A couple more tips. Sometimes we see visas get denied, the O1 visa gets denied at a consulate abroad. So this is where your petition was approved here in the US. You go abroad and for some reason the embassy says, nope, we think that you're not extraordinary enough, you don't meet the standard, and they deny you. Now, the authority here is they cannot summarily re-adjudicate the approval absent fraud or misrepresentation. So this would be an error if they do that. And this is something you definitely want to talk to an attorney if this becomes an issue. Alternatives to O1, like I said, if you can get an O2, if there's an O1 working on a movie, TV show, or project that you want to work on, you must be able to show that there's a prior working relationship with the O1. The essential support personnel for O1 artist or athlete is the O2. It only works in the context of artists or athletes, doesn't work in science, business, or education. The O1 must remain in place. If the O1 changes, gets a green card, leaves, you the only option you really have is trying to transfer your O2 to an O1. If you're strong enough for an O1, you could potentially upgrade from an O2 to an O1 in your own right, but you need to follow all the other steps we just went through. The O2 does require a separate petition. They often do need separate consultation letters for each O2 as well. The idea is that they're going to be assisting in the performance of the O1 alien. They're an integral part of your performance, and they have critical skills and experience with the O1 that are not of a general nature or possessed by a US worker. So the idea here is if it's a manager, for example, you can show that you've worked with them for 15 years outside the country, and therefore, they don't possess general nature skills. It is actual critical skills and experience with you. With film and TV, you are looking for a pre-existing long-standing working relationship, or if you kind of look at this what we call a mid-production O2, which is where production filming has taken place outside the US. The continued production will take place in the US, and we're showing that the alien is essential to the completion of the production. P visas, these are basically available for internationally recognized athletes or an entertainment group, normally issued for 5 years for individual, 1 year for team groups. It's a lower standard than the O1. We have to show international national renown and 2 of the regulatory criteria. P1S, this is basically the P1 equivalent of the O2. It's for support personnel with a P1 who are, coach, manager, these kind of people who are traveling with the P1 athlete. There exists P2, which is equity visas, generally for reciprocal exchange programs, and P3, culturally unique performers. 2 ways of getting a P visa generally have 2 classifications. There's the internationally recognized athlete. If you're coming to the US to perform as an athlete, either individually or as part of a team, to compete at an internationally recognized level of performance. P1B would be a member of an internationally recognized entertainment group. If you're coming as a member of this entertainment musical group that has been recognized internationally as outstanding for a sustained and substantial period of time. The criteria for a P1B, at least 75% of the members of your group must have had a substantial and sustained relationship with the group for at least 1 year. The group must be internationally recognized, having a high level of achievement in a field evidenced by a degree of skill and recognition substantially above that ordinarily encountered. And the reputation of the group, not the individual achievements of its members or the acclaim of a particular production, is essential to these cases. Individuals not performing as part of a group are not eligible and should apply for an O1 instead. As I mentioned, with the culturally unique P3, you have to be coming to perform, teach, or coach as artists or entertainers individually or as part of a group under a program that is culturally unique. To show evidence of one-time achievement, this is looking at the group's significant international award or nomination, or at least 3 of the following. The group has performed, this is kind of going back to the starring or leading entertainment group in production events which have a distinguished reputation. The group has achieved international recognition and acclaim for outstanding achievement, performed and will perform services leading or starring group for organizations and establishments that have a distinguished reputation. You can show commercial critically acclaimed success. You've got significant recognition for achievements from critics, organizations, and your group has commanded and will command a high salary or other substantial remuneration. What do you need? Again, similar to the O1, you need forms, you need support letter, you need evidence, and potentially a consultation from the appropriate labor organization about the nature of events to be performed, or a statement proving that your group has been established and is performing regularly for a period of at least 1 year. What other visa options are available? The B2 can be available for amateur entertainers. This would be a person who is an amateur in an entertainment or athletic activity, not member of any of the professions associated with that activity. The idea here is that you're not paid except for incidental expenses or prize money, which is okay. Or you're performing in a social, charitable, or as a competitor in a talent show, contest, or athletic event. There is B1, which is the business visa for other entertainers, artists, and athletes. And the Foreign Affairs Manual, that citation there, does address specific situations that this can happen, such as still photographers, artists, and musicians. You can apply for an E2 visa. The idea here would be you're going to basically set up your own production company. There's only certain countries that have an E2 treaty, but if you're from one of them, you could technically set up your own company, set up your own production company, and then come to run it. This particularly works for producers and directors. The idea here is that you have to show you've made a substantial investment in the US, which generally speaking can be anywhere from around 200,000 and up, and that money needs to basically be spent. E3 H1B, this can sometimes work if you're behind the scenes in a kind of a graphic designer role. You have to be able to show that the position is a professional position requiring at least a bachelor's degree. TN, again, there is actually a TN classification for graphic designers. This can work for Canadians or Mexicans who meet the criteria and can come in on that side of things. We have seen iVisas be used. iVisa is a journalist, is basically kind of an international media visa. You have to be a member of the foreign media to work in the US for a media organization which has a home office abroad. There is the H3 or J1, which are basically both trainee visas. These can work in certain situations, but generally unlikely. Moving on to the green card side of things. So we talked about the O1. The O1 is a non-immigrant visa. The idea is it's only for a few years. You're going to be here temporarily, and then you're going to leave. The EV1 is an immigrant visa. The idea here is that you can actually, you get a green card, and you can petition on your own, or you can have an employer sponsor you. And it's a higher standard than the O1. Extraordinary is basically defined as level expertise, indicating that you have one of that small percentage who has risen to the very top of the field of endeavor. An O1, because you got an O1, it doesn't necessarily mean you're going to get an EB1, because the standard is higher for the EB1, but I think it tends to be seen as kind of a nice stepping stone, or at least the idea being that at least immigration has said you meet this lower standard, so it's less of a leap to get to the EB1 standard, which is higher. As I mentioned, it can be self-petitioned, so you don't actually need an employer to file for this. You can do it on your own. And this would be the green card, and like I said, it's this higher standard. In order to qualify, you have to show that you have sustained national or international acclaim and that your achievements have been recognized in the field of expertise. This is where we're going to go into criteria again, because either you show one-time achievement, which again could be the Oscar or Grammy or something like that, or at least 3 out of the 10 criteria. And this really needs to be heavily documented. Criteria for extraordinary ability includes lesser national or international prizes or awards. This would be awards that show that have kind of some kind of national or international scope, highly prestigious in nature, you've received an award for excellence in the field, this kind of thing can work. Membership in associations requiring outstanding achievements. This is evidence. The issue on the membership criteria is that we really need to be able to show the stringent criteria for membership. It's not just a case of, you pay a membership fee and you become a member. This really has to be that the association kind of only lets the top people in. Only if you can show you've been picked for excellence in your field, such as if you're a member of the academy or something along those lines. If it's something that you're going to pay, that you can basically welcome anyone as long as you pay the fee, probably not going to work here. But if it's something that you have to be nominated for, or they will select you, it's more likely to work. Next criteria would be published materials. We've kind of covered this. Participation individually or on a panel as the judge of the work of others. If you ever get the chance to go and sit on a panel or act as a judge, this is really, really useful, because it's one of the criteria that they're little bit nicer on, and the idea is that you're judging the work of others in your field. Another criteria is showing that you've made original contributions of major significance. This would be a case of showing that somehow your work in the field has just made waves. You've really kind of gone out there and made big changes. You've revolutionized the way that people see this particular field. This works particularly in the arts, in the graphic arts, the VFX, these kind of things, because people are able to show that their particular software, for example, that they've come up with, their particular design technique has revolutionized the field. And this is definitely a good one there. If we can show you've authored scholarly books, chapters, articles, this kind of thing can definitely work. Like it says there, a scholarly book article, USCIS really has its own ideas as to what that means. Display of work at artistic exhibitions or showcases. Again, this is usually performing arts, but I think it's a good argument to make if, for example, you starred in a movie or you directed a movie that was shown at a particular film exhibition or something like this. I think this is definitely a good one to shoot for. Critical leading role for distinguished organizations is very similar to the O1, but we do need to be able to show it's a very critical leading role for this organization. High compensation, again, very tough one to hit, but if you've got it, go for it. Commercial success, generally they're really interested in how you actually contributed to the commercial success. If you were part of a major movie, how did you make that movie, how did your kind of contribution to that movie lead to it making so much money? And that's where the reference letters can sometimes come in. The process with the EV1 green card is we file the I-140 petition first, which is the immigrant visa petition. You can premium process this as well, which means you pay an extra $1,225 and they'll adjudicate in 15 calendar days. Some people think that leads to a higher risk of RFE, request for evidence. I don't know if that's necessarily true. Seen RFEs kind of come on both cases. Some people say that if you premium process a case, it's going to go to a supervisor, so they're more likely to issue a request for evidence. But I think the same is true of the fact that if they premium process, maybe they don't have as much time to look through everything, so maybe they go ahead and approve it quicker. It's kind of one of those things that I don't know if really there's much difference. Once that's been approved, you file the second stage. Now this is either IVP, which is immigrant visa processing, where you file and kind of process your green card or immigrant visa application abroad. This can take maybe quite a while sometimes. Or if you're in the US, if you already have an O1, you can file an I-485 application to adjust status. This would basically allow you to switch from the O1 to the green card here in the US. You can file both these stages at the same time, or you can file them separately. The only reason people generally file them together is because if you file the I-485 application to adjust status at the same time as the immigrant visa petition, 60 to 90 days after you file the I-485, assuming the I-140 hasn't been adjudicated in that time, you get a temporary employment authorization card that allows you to work and travel abroad without abandoning your application. The problem with doing this is if the I-140, which is obviously a lot more subjective portion, which is the EV1 portion, if that gets denied, you lose all your government filing fees for both applications. Current issues, just a few practice tips. USCIS can be very unpredictable. As I mentioned, the I-140, EV1, and the O1 is a very subjective standard. In certain situations, the weaker cases go straight through without any problems at all, and the stronger cases run into major issues. It can really depend on what officer you get. If you get denied, should you reapply? Well, appeal is actually taking probably 2 or 3 years sometimes. So generally speaking, it seems to be best if you kind of prep with new documentation, get some stronger reference letters, this kind of thing, and reapply. Sometimes in that regard, when you reapply, next time it gets approved. Texas Service Center versus Nebraska Service Center, premium versus regular, does it really matter? I think it's one of those things. Different attorneys will tell you different things. Some people swear by the fact that Texas Service Center is better than Nebraska, or there's better adjudications out of there. I think at the end of the day, it's often kind of more of a superstitious thing. I think sometimes it's the case, but officers do move around from service centers to service centers, so they may well move from one of those service centers to the other, and suddenly one gets worse. You really do need, for the EV1, this 3+ strong criteria and good evidence to support all of your claims. Provide as much evidence as possible. Never assume that the officer is familiar with pop culture. You really want to kind of school them on how YouTube hits work and what that means and how that shows popularity of the particular video, for example. The last bit here is that we really want to address the Kazarian framework. Now, the Kazarian is basically just the name of a case that was passed down, and the idea behind Kazarian is that even if you meet 3 of those criteria, there's a final merits determination which has to be addressed. This is where the immigration officer will consider all of the evidence to determine whether you've sustained national or international acclaim and that you're one of that small percentage who has risen to the very top of the field of endeavor. Now, these are kind of things where, if you hit, we've seen some people, you'll hit 3 criteria, but they'll still deny you on the second final merits determination. And it's tough because really, to some extent, the idea seems to be that if you meet 3 of those criteria, you qualify. But if you only just meet 3 of those criteria and the officer really doesn't like your case, they can still deny you on the second stage. So you really do want to make sure you hit as many as possible, and you also want to make sure that you address the second stage in terms of being able to show that you've sustained national or international acclaim and that you're one of the small percentage. Requests for evidence do happen. Don't take it personally. They actually come out a lot. You'll often, when you read the request for evidence that you get on your petition, a lot of times they can be pretty much copy and pasted from a template request for evidence that immigration uses. So some of it may be completely irrelevant to you. I've seen so many times in the request for evidence discussion saying, make sure anything you submit comes with translations when everything was in English language. Everything that was submitted previously was English, and there's no reason that anything would need a translation, but they still include that kind of information in there. But when you get a request for evidence, you really want to make sure you read it carefully. They sometimes have errors, and they may contain inaccurate statements of fact and law, so you really want to make sure that you evaluate them and make sure you know what is the officer really asking for. Are they going beyond their realm of questioning, basically, by asking for documents that you shouldn't really need to be able to show? And you can only, at the RFV stage, at the request for evidence stage, you can only submit evidence that was there at the time of filing. Nothing new can be added to the record. So this is kind of one of those things where we always say, if you file your O1 application and then win the Oscar the next day, technically, they're not able to look at it. If you get a request for evidence and they say you don't qualify because you don't meet this particular standard, you can't show the Oscar because it wasn't there at time of filing. If you have an employer sponsorship, we'll briefly kind of go over this. There is the EB2 exceptional ability category, which is a lower standard. It's exceptional instead of the extraordinary. Science, arts, or business, you may be able to include sports in there. Or standard would be degree of expertise significantly above that ordinarily encountered. This does require a degree. There is a PERM process, which is a labor certification process, unless you can file for Schedule A designation, which is limited only to sciences and arts. So it's a good option for animators, VFX artists, etc., but it's not good for others in entertainment because you need this employment sponsorship. For EB2, exceptional ability criteria, you must meet 3 of the following. You must be able to show a degree, in an area of exceptional ability, letter from current or former employers showing 10 years of experience, license to practice, high salary, membership in professional associations, recognition for achievements, and any comparable evidence. So these are things that you would need to show at least 3 of. Finishing up, I think that should be about it. We're pretty much almost all out of time. If anyone has any questions, please shoot them through. I've answered a couple of them that I saw as they were coming in. But if you have additional questions or want to see if you are eligible for an O1 or an EB1, please feel free to shoot me an email at richard@wolfstorf.com. Or there's my direct phone number there as well. You can call me and we can just go through it and see if you qualify. I will wait a couple of minutes in case anyone else has any additional questions. Feel free to type them in and send them through, and I'll try and answer as much as I can. Okay, I have one question here. Do you have to go outside the United States to renew an O1? No, you don't. Basically, if you file an extension of status here, you can continue to stay here once, while it's pending, or once it's approved, you can continue to stay in the US. The problem is once you travel outside of the United States, even if you're not going to your home country, if you're just going somewhere else, you do need to then apply for a new O1 visa to be added to your passport before you come back into the country. So you do need a new O1 visa in your passport if you're going to be traveling internationally, but you don't have to go outside to renew the O1. We also have a question here about where an agent is petitioned and has multiple employers. Does the agent need to sign contracts with every employer, or is one document agreeing to the representation agreement sufficient? Yes, basically if your petitioner is an agent or a manager, you're good. You basically have a production company give you a deal memo between you and the production company showing that you've got a project for that period of time. And I think that's about all we've got time for. So if anyone else has any other questions, shoot me an email at richard@wolfstorf.com or give me a call at 310-570-4075. Otherwise, thanks for joining me today. And